Mr. Deputy Speaker, this bill is a significant step towards a more accountable digital space. Specifically, it gives victims of online harm new avenues through relief through Commissioner of Online Safety, impose clear duties on online service providers, and create civil rights of actions for victims. This bill is close to my heart because I've met Singaporeans who suffered from the harms described in Part 3 of the bill. For them, the humiliation and emotional distress that they've gone through are overwhelming. This bill, if implemented well, will go some way to deter perpetrators of online harm, give victims of online harm much clearer routes of recourse. Against this backdrop of my support for this bill, I would like to seek clarifications on how this bill works in practice across 5 areas. My first clarification is about operational tempo and service standards of Commissioner Office. On operational tempo, the bill rightly allows victims to seek the Commissioner intervention without first going to court. Beyond being fast, we must also communicate what is being done fast. This means the effort should be made to lay out the process as clearly as possible to the general public so that the victim knows what action will be taken and what to expect from the moment they decide to make a report. You see, it makes a difference by telling someone that within a certain number of hours they will receive a response versus telling someone over X number of hours, actions A, B, C will be taken and they will be updated at the end. As part of implementation, the Commissioner should also consider issuing advisory guidelines that sets out triage principles, communication milestones, indicative responsive time across various categories of online harm by severity. On service standards, Clause 23 in Part 4 enables victims to make a report alleged online harmful activity. But while the bill mentions that it aims to provide a timely means of redress, it does not yet prescribe what counts as a timely response. The point here is this: online harm spreads by hours, not by weeks or months. Hence, I wonder if the Commissioner Office can consider setting and publicly communicating service standards of target response time for various categories of online harm by severity. Saying this, I'm cognizant that speed also requires resourcing. The Commissioner Office should be staffed and supported to act with urgencies. I would welcome the Ministry plans for resourcing so that operational targets are achievable rather than aspirational. I also think that it is more appropriate to leave service expectation and operational KPIs as guidelines as compared to statute. Because hard timelines in primary legislation like this bill may risk overwhelming staffing when spikes in online harm cases occur. Hence, guidelines can be updated swiftly and calibrated to capacity at the agency level so that the bar can be set at achievable and meaningful. To strengthen this approach, the Commissioner should also consider having a standing advisory group of relevant practitioners such as technologists, clinicians, child safety specialists, academics to refresh workflows, KPIs, and give guidance on online harm periodically. My second clarifications involve accessibility and public readiness. Clause 23 of Part 4 provides that victims can report online harms to Commissioner. But it's also equally important that they know how to do it. Online harm victims will also include those who are less technologically savvy. It is hence vital that we ensure that the process of online harm reporting is kept simple, multilingual, and accessible. This could mean ensuring that the online and mobile service platform use plain English, not technical jargons, and official language to communicate to a public, and guide victims of online harm through reporting. Proactively providing step-by-step guides via major online and mobile platforms so that they know how to fill an online harm notice. At the same time, setting up offline helplines and community touchpoints for those who are digitally less confident users to keep informed of the work of the Commissioner and the Office. Clause 94 in Part 12 of the bill also allows victims to send an online harm notice to a service online provider. This is a positive step towards direct accountability. But for this to be utilized effectively, online service providers must make sure that reporting is easy to find and use. In this regard, will the government, along with the Commissioner and Office, study how major platforms will implement their online harm reporting in practice, consider whether they are accessible, especially to the vulnerable users? For instance, sending an online harm notice within a mobile app or website should never require a user more than 20 minutes navigating multiple different landing pages and entering unnecessary inputs that the provider would have already gotten from the moment they're registered for an account. You see, these features are not cosmetic because they determine whether victims can exercise their rights effectively. Thirdly, we should also consider the practical aspects of civil proceeding and course of justice. The bill introduces statutory torts which give victims the right to bring civil proceedings for defined harm, such as intimate image abuse, child abuse image, etc. Hence, civil action involves practical hurdles, legal costs, disclosure processes, emotional strain. I would like to ask the government to provide more clarity on what typical steps will be for a victim to bring such proceedings, and whether there will be support measures, especially for those who might not have adequate financial resources to do this. The Commissioner and Office should consider communicating the availability of these resources from the onset. Because at the end of the day, justice should never be determined by income. This upfront assurance will reduce the barriers to entry to report and deter actions of perpetrators. My fourth point of clarification is on issues related to damages, humiliation, and redress. Part 5 of the bill on the directions and order of the Commissioner, as well as Part 13 of the bill on damages and remedies, provide various reliefs and remedies to victims of online harm, such as removal of content, account restrictions, and compensation. However, I would like to seek clarification on whether non-monetary losses could also be considered within this bill framework. This may go further in helping the victims to rebuild their lives. Relatedly, public communications and victim-facing materials by Commissioner and the Office should be trauma-informed and non-stigmatizing. They should state plainly that the responsibility lies with the perpetrator and not interpretation that clothing, occupation, social activity has caused harm done to them. This is important because victim blaming deters reporting, and delay helps speaking, and compounds humiliation and distress. My final point, prevention and safety by design. Deterrence after harm is necessary, but prevention of online harm upstream is better. This bill defines serious harm clearly, but we should also work to ensure that major online platforms operating here continue to prioritize user safety and privacy by design principles. This includes features, age-appropriate design, high privacy default applied for minors, safer recommendation setting for young users. Such upstream measures would ensure our protections are not only reactive, but proactive, making digital environments safer before harm occurs. Hence, I hope the government will actively work with major online and mobile platforms on this. In conclusion, Deputy Speaker, this bill gives Singapore a strong framework, defines harm, swift administrative direction, civil routes for redress. But to make online safety real, we must pair with speed, prevention, and accessibility. This is how we build an online environment that is safe, fair, and inclusive, while upholding responsible speech and due process. I stand in support. Thank you.